Well, I want to welcome everybody to tonight's We the People meeting. We the People is for the people. And we have an exciting speaker tonight, Mr. Stephen P. Rice, who is managing partner and head of the litigation group in Kroll and Mooring in Irvine. However, this is a international law firm of over 500 attorneys based in Washington, D.C. Steve graduated from, he got his law degree at Harvard Law School in 1980. He has been working as an attorney for 30 years. He doesn't look that old to me. He was named the Attorney of the Year by the Public Law Center of Orange County for excellence and dedication in pro bono work. He was the lead trial and appellate attorney for 6 Seal Beach Leisure World homeowners in the recent litigation with Golden Rain Foundation, in which it was successfully established that Golden Rain Foundation is subject to the Davis-Stirling Act. We are pleased. We're all excited about that outcome. We are pleased to introduce Mr. Stephen P. Rice. We ask that you hold your questions until Q&A, and we will begin the presentation. Mr. Rice.
Is it working out? No? Okay, are we good? Yeah. All right, great. Well, I'll start over again. Good evening, everyone. It's a real pleasure to be here. Normally when I give talks like this, I like to wander around a little bit. Okay, I like to wander around a little bit and kind of interact a little bit more with the audience, but I've been told that since this is being videotaped and the videographer has a frame here at the podium, that I can't move around too much. I have to stay right here at the podium, so that's what I'm going to do. But in any event, it's really quite remarkable that we have an entire large room full of people to hear a talk about a legal issue. And I think it's a tribute to all of you and to the community that you have here that you're able to attract a crowd like this for a subject matter like I'm going to be talking about. I've been involved in one form or another with Seal Beach Leisure World for, it's been a while now. It's been, 5 years or so, over 5 years in connection with various issues. And although I know there are disagreements within the community on various issues, you have a wonderful community. You have a community full of engaged, interested people, and that's what really makes it a great place to live, notwithstanding the differences of opinion that you may have. And so one thing that I wanted to convey right from the start is that not everybody in this room is going to agree with what I'm saying, may not agree with some of the answers I give to some of the questions, but it's great that we can have a civil discourse about the issue. And that's why I agreed to come here tonight, is because I was confident that we could have a civil discourse about issues that are important to your daily lives and to your entire community. And so hopefully this evening can contribute, at least in some small way, to the discourse, the broader discourse and discussion that you're having in the community. So that's just kind of by way of introduction. I was asked to come here tonight to address the question of what is Davis-Stirling, why is Davis-Stirling important. So I'm going to talk a little bit about that, and then I'm going to talk very, very briefly about my understanding of some of the issues that are specifically facing you here in Seal Beach Leisure World, and then I want to leave plenty of time for questions, because I know there are a lot of people in the audience who have questions. And so I'll probably talk for, 10, 15, 20 minutes maximum, and then we'll have plenty of time for everyone to ask questions. Some of these issues, by the way, don't necessarily have right or wrong answers. There is room for discussion and disagreement. I think ultimately, to all these questions, there is a right or wrong answer, but sometimes it's hard to see, and reasonable people can disagree, and that's part of the civil discourse that we're having. So, as far as the Davis-Stirling Act is concerned, let me start out by saying that what it is at its core and what it was enacted to be was a consumer protection statute, a homeowner protection statute, to give the people who live in homeowners associations rights and control over their community that they wouldn't otherwise have. Without the Davis-Stirling Act, homeowners associations, community associations, the common interest developments, the people who live in them would not have the rights over their affairs that the Davis-Stirling Act conveys. So that the primary purpose of the Davis-Stirling Act was to make sure that the residents of common interest developments had established rights that were set in stone, in statutory language, and they would not be subject to the changes that could occur if the rights were determined by different management groups that might come in, or different boards of directors that would come in from time to time, for better or worse. Some boards might want to give more rights, some boards might want to give less rights. The purpose of Davis-Stirling was to eliminate all that uncertainty and establish what the rights of the residents of common interest developments are. And so that's what it is. It's a statute that's intended to benefit homeowners. There's nothing nefarious about it. There's nothing that people should be afraid of. It really was intended to be something to benefit individuals, the individuals who live in common interest developments, and make sure that the whole wide array of rights are protected. Well, what are those rights? The rights that are extended by the Davis-Stirling Act really fall into three large buckets. And the statute is quite long, and it's fairly technical in parts, and there are a lot of things that are discussed in it. But I boiled the statute down really to what I call three buckets, three bundles of rights, three general topics that the Act is intended to address. The first bucket relates to the governance of a common interest development. What I include within governance are things such as election procedures. So the procedures that apply to the elections for boards of directors, inspectors, when elections have to occur, those sorts of things. So there are established procedures for elections. Another governance issue that's addressed in the Davis-Stirling Act is the issue of open meetings. That's a very important purpose of the Act, open meetings, to establish when boards of directors can close their doors and discuss issues in private, and there are some issues that boards of common interest developments are allowed to discuss in private. It's very, very limited. The main purpose of the Davis-Stirling Act with respect to open meetings was to have meetings out in the sunshine so that anyone who cared to participate could attend and listen and speak their mind if they chose to the people who are the decision makers. Another important governance issue that's addressed in the Davis-Stirling Act is document access. The Davis-Stirling Act very, very carefully and at length lists the documents that the members have access to on request. And it's a pretty impressive list of documents. It relates to the finances of the development. It relates to contracts. It relates to basically most of the things that a common interest development does. The documents that relate to those things are accessible by virtue of the Davis-Stirling Act. Another governance issue that the Davis-Stirling Act addresses is the rules that managing agents of a homeowners association have to follow. And that's very important because managing agents are hired by the association to work for the association. But absent the Davis-Stirling Act, the members of an association would not have any rights directly against those managing agents. The Davis-Stirling Act, though, says that, for example, the document access rights that a member has directly against the association, they also have against managing agents, so that a homeowners association can't effectively secrete documents away from the members by leaving them in the possession of a managing agent. So the statute has a section on the obligations of the managing agents of a homeowners association, and that's a very important governance issue because it makes sure, again, that you have transparency. And I think transparency really is the primary governance theme of the Davis-Stirling Act, making sure that the members have access. And what can be bad about members having access to the information that relates to how their own community is run, how their own money is spent, what their leaders, their elected leaders, are doing. And that was what the legislature felt when they enacted Davis-Stirling many years ago. And I think it's kind of a common sense principle that you all, as members of an association, and at least Golden Rain Foundation in Seal Beach Leisure World as of now has been legally established to be a homeowners association subject to the Davis-Stirling Act. What can be bad about the members having access to documents, to being able to attend meetings, to be able to have free elections as provided in the Davis-Stirling Act? So that's the first bundle of rights, are these rights that relate to the governance of the community. The second bundle of rights are rights that relate to the operations of the common interest development. So, for example, the Davis-Stirling Act prevents the common areas from being partitioned except under, or divided up, or sold, or disposed of, except under very limited circumstances and subject to controls that the statute lays out. Another operational issue that the Davis-Stirling Act addresses is the preparation and dissemination of annual budgets. Since homeowners associations are typically run by boards of directors that are lay people, and they have a variety of experiences. Some may be business people in their real lives. Some may be have other careers. They're not necessarily experts in managing homeowners associations and their finances. So the Davis-Stirling Act requires that, as far as the financial operations of the community are concerned, that budgets, regular budgets, have to be prepared and sent out to the community. Another operational right that the Davis-Stirling Act creates relates to reserves and reserve analysis. And that's really very, very important as well, because there are a lot of facilities in a community, such as Leisure World or any other common interest development. And those facilities, whether they be streets, whether they be a clubhouse like we're in now, whether they be other types of common facilities, landscaped areas, what have you, they deteriorate over time. They need maintenance. And that maintenance, in large part, you need to set money aside for it. You can't just count on money being available at any particular point in time if you have a large maintenance expenditure that's necessary. So the Davis-Stirling Act imposes some structure on the reserve process by requiring that reserve studies be done and thereby encourage the associations to make sure that money is set aside for important expenditures that may need to be done and will need to be done in the future. Insurance, that's another operational issue that's addressed in the Davis-Sterling Act. The details of insurance have to be distributed out to the members, and adequate insurance has to be purchased. And that includes general liability insurance, fiduciary insurance, and the like. The Davis-Sterling Act also addresses operational details relating to assessments. How much the members of an association can be charged, how much the assessments can go up from one year to the next, when special assessments can be levied, these sorts of things that relate to the money that the members of the association have to reach into their pocket to pay every month. So the Davis-Sterling Act regulates that. The third bundle of rights, and it's a smaller bundle, but in a way it's equally important with the others, relates to what you might call remedies and dispute resolution. So, for example, if a member of a homeowners association requests documents and those documents are not provided, the Davis-Sterling Act establishes what the remedies are for that member to obtain those documents. It establishes the procedure by which the documents can be obtained in a very consumer-friendly way, specifically small claims court, so that lawyers don't have to get involved and things can be done quickly, efficiently, and cost-effectively. There is also a section of the Davis-Sterling Act that deals with alternative dispute resolution, so that before lawsuits are filed, parties need to go through a mediation or an arbitration process to try to resolve their disputes amicably before they go to court. So this whole issue of dispute resolution is a very important bundle of rights the Davis-Sterling Act addresses, because it helps manage how inevitable disagreements in a community are resolved, and helps establish a procedure for the resolution of that type of dispute that is, as I say, efficient and in the interests of both sides, both the governance of the community, the community leaders, and individuals who may have grievances that they want to bring forward. In addition to these three bundles of rights, the governance, the operations, the dispute resolution that I've talked about, there are a host of other things that the Davis-Sterling Act does as well, and I won't go into those in detail, but one of the ones that may be particularly relevant to you right now, given some of the issues that are being discussed here, are rules that relate to the amendment of governing documents and the change of governing documents. And the Davis-Sterling Act creates procedures for how the community goes about changing its governing documents. Another issue addressed in the Davis-Sterling Act relates to ownership rights and interests, the separate ownership rights and interests of the members of the association. So this is a real quick word. I spent about 10 minutes on that or less, of a very high-level review of a very complicated and lengthy statute. But it gives you an idea of the sorts of things that are included in the statute, intended to benefit individual residents. And that's consistent with the theme that really is part of our democracy more broadly, which is that we do protect the interests of the little guy as much as we can. We do respect the rights of people who have minority views and so forth. And so there's something democratic about the Davis-Sterling Act as well. There's nothing undemocratic about it, because it is not something that gives power to small groups. It's a statute that gives rights to everybody and gives those rights to everybody in the development equally. So I think it's a very, very democratic statute. That was what I wanted to say about the Davis-Sterling Act. There may be specific questions about it, and I'll be happy to answer those when we go into the Q&A. The last thing that I briefly wanted to touch on before we open the Q&A is just a few observations about things that I understand are going on here in Seal Beach Leisure World. We know as a result of the court case that ended in 2008 that the Golden Rain Foundation is an association subject to the Davis-Stirling Act. And there were a lot of people who disagreed with that in the community, and there were some people who did agree with it. But that issue is over. That's been decided by a court. It was decided by a trial court. It was decided by the Court of Appeal. And then the Supreme Court decided not to review the Court of Appeal opinion. So that issue is final. As of right now, Golden Rain Foundation is an association. So with respect to Golden Rain Foundation's operations, its control over the common facilities and the other things that it does in the community, all the rights of the Davis-Stirling Act apply, and Golden Rain needs to conduct itself in accordance with the Davis-Stirling Act. There's also, I don't think, any dispute that Mutual 17 is subject to the Davis-Stirling Act. It's condominiums. It was formed later in time. It has what you would call traditional CC&Rs, covenants, conditions, and restrictions. And I don't think there's a dispute that it's governed by the Davis-Stirling Act as well. Then there are all the other mutuals, which are stock cooperatives. And I think it was assumed by the judges who decided the Golden Rain case, both the trial court judge and the appellate court judges, the three-judge panel that decided the case on appeal, that the mutuals probably were subject to the Davis-Stirling Act, but they did not decide that issue. That issue wasn't before them, so they didn't decide that issue in any final and binding way. So I know there's discussion going on in the community right now. Are the mutuals, setting aside Mutual 17, subject to the Davis-Stirling Act? My view is that they are, that they do have all of the indicia of a association, just as the Golden Rain Foundation does. But that's an issue that as a matter of the courts, hasn't been determined. And I would actually hope, for your sake, that it wouldn't have to go that direction, because it's so expensive and disruptive to have it resolved that way. But again, this is an issue that will evolve out of your community discussion, whether or not you'll be able to reach a consensus that people can live with as to whether they are or are not a Davis-Stirling Act entity. So that's all that I wanted to say as part of this part of the evening. Again, thank you for attending and listening so patiently. We can go now to the Q&A, and we have a microphone here in the center for people to line up behind, and I'll do my best to answer questions. Before we go into that, one other thing I should clarify is that the views I'm expressing here tonight are my personal views. Yes, I'm a lawyer. Yes, I have some experience in this area. These are my personal views, though I'm not speaking on behalf of my law firm. I'm not giving anyone legal advice here tonight. I'm just providing information and helping the perhaps in some way, as I said, the discussion that you're having here in the community. So I just wanted to say that before we went into Q&A. So,
before we start with the first question, and Mr. Price has a airline plane waiting for him at 9 o'clock. So we'll be taking the last question at 7:45, and we'll conclude. When he concludes, he'll need to leave.
One important point of clarification there. I have a Southwest airplane waiting for me. My private jet is out of commission, so I don't have a private jet. I have the plane that's waiting for me. I'll stand in line like everybody else.
With all those credentials, I just assumed it was a private jet.
Mr. Rice, on your last subject, Okay, on your last thing regarding the mutuals and whether they're under the Davis Stirling, what about reincorporating the mutuals under a nonprofit mutual benefit? Regarding that, I don't know what the tax consequences are, but that seems, it might be logical, but you would know better than I do. That's my question.
Well, the mutuals right now, setting aside Mutual 17, as I understand it, are set up as general law corporations, not nonprofit corporations. There is an issue as to how they've been functioning, and the way they've been functioning over these past 4 decades may be different than their formal legal status would suggest. Excuse me, but it certainly would be possible for the mutuals to convert themselves from general law corporations to non-profit corporations, and there's a process that would need to be gone through to accomplish that objective as a matter of corporate law.
My question's somewhat related to that. Okay, my question is somewhat related to that question in that in our mutual, for example, Mutual 2, this has come up, and we've had our leaders say, well, we can't be under Davis Stirling because we are a for-profit corporation. And so we've raised the question that, well, let's change it. And the answer's always been, it's prohibitive cost-wise. So would you have a comment to make about that?
Yeah, I would have to disagree that it would be prohibitive cost-wise. I can't give you an idea of how much it would cost, but it's something, if estimates have not been obtained, it would seem that that would be at least a logical step, so you have objective information as to whether it was or was not prohibitive and exactly how much it costs. So the first step would be to get, if this was something that the mutuals were interested in, would be to contact a couple of lawyers, get estimates from them or quotes from them as to what the cost of that would be, and then there would be specific information as opposed to speculation as to what it would cost. So that would be one response to that would be to make sure that the statements such as that are based on actual estimates of the cost as opposed to fears that it might be a lot of money when in fact it may not be a lot of money at all. The second aspect of your question relates to whether there's a need for the corporations to change status at all to fall within the Davis Stirling Act. And one of the lessons of the Golden Rain Foundation case is that the courts look at substance over form. And if in substance these corporations have been acting and are acting as nonprofit corporations, then they will be regarded for Davis Stirling Act purposes as nonprofit corporations, even if they are structured as general law corporations. So again, the law tends to look at substance over form, and so that would be another aspect of the analysis, is how have these entities been functioning. If they have been functioning as general law corporations, that might lead down one road. If they've been functioning as nonprofit corporations, that might lead down a different road.
Is it possible to not have a lawsuit and still get a court ruling? In other words, to go to the court and say, here's our bylaws, here's our documents. Do you feel that we would be under Davis Stirling?
That's really a fantastic question. That's just a really, really good question. And there are a number of procedures available to resolve an issue like that wouldn't involve the long time, the expense, the upset of adversarial litigation. And one way would be to submit it to binding arbitration, and you'd select a retired judge or a group of retired. You could even have a panel of 3 retired judges or arbitrators who would decide the issue on a binding basis. And you might, as part of that, preserve right of appeal so that the arbitration judgment could be appealed up to the Court of Appeal. But arbitration, generally speaking, not always, but generally speaking, is a less expensive, more efficient process. Another alternative would be to do what's called really kind of a friendly lawsuit, where the parties recognize that they have a disagreement. The parties recognize that for the benefit of the community, it would be important to have the issue resolved. And so what the parties do is that they agree, okay, a lawsuit has to be filed, but we're not just going to rush off and take a lot of discovery. We'll agree up front that a lawsuit is going to be filed. We're going to agree up front on a procedure for collecting the evidence and exchanging the evidence on both sides, and then presenting it to a court for decision, whether it be by what's called a motion for summary judgment, where the court just decides the issue on papers and brief oral argument, or whether it would be by a trial, but a trial that's based on effectively stipulated facts. Because what really is going on, this was certainly true in the Golden Rain Foundation case, and I think it's true with respect to this issue of the mutual status as well. The facts are known. The question is, the dispute is, what's the legal effect of those facts? And so, if the facts are in fact largely undisputed, then either of these mechanisms that I'm talking about would make a lot of sense. And there are other alternatives as well, but those are two suggestions. And certainly coming up with a way of resolving the issue in a way that doesn't cause the disruption, expense, etc., of protracted adversarial, antagonistic litigation and expose the participants to personal vilification and so forth for being involved in it, that would be wonderful for all concerned.
If a mutual was to submit a request for the court to decide if they were under Davis Stirling, they would need a lawyer, right?
Yes, because this is
But then would there be any way that another entity could come in and try to make it a lawsuit?
I'm sorry, I'm not following that question.
Okay, if a mutual decides, we just want to have our lawyer go in and petition the court to decide, based on our documents, the way we operate, whether or not we're under Davis Stirling.
Right.
Okay, so it's submitted, but could another entity, another mutual, another group of citizens come into that and say, hey, this affects us, so they would make it into a lawsuit? Can that happen?
Well, you're raising another good kind of case management issue. You've got, how many mutuals are there aside from 17? 15? 15, you have 15 mutuals that raise exactly the same issue, and the facts may be somewhat different between those 15 mutuals, but the facts are probably going to be generally similar. So you would have a choice as to try to resolve the issue mutual by mutual, in other words, do it 15 times, doesn't seem very efficient to me, or having the issue just done once, and all the mutuals would be able to participate, and it would just be one proceeding that would be managed efficiently, and the issue would get resolved for the entire community, all the mutuals, all the stock cooperative mutuals, at once. Now, lawsuits, there does have to be two sides to a lawsuit. So whether it's a member initiating the lawsuit or the mutuals initiating the lawsuit, there do have to be two sides. But that can be something that's discussed before the lawsuit is even filed, so that we know who's going to bring the lawsuit. Is it going to be a declaration that's sought by the mutuals, or is it a declaration that's going to be sought by one of the members, and who's the other side going to be? But there would have to be two sides. It's not just a matter of the mutuals going in by themselves. They really can't do that. There needs to be another side, a vehicle for people who have views that may be different from the views that the mutuals might be advocating to express themselves and be heard by the court.
Mr. Rice, can you hear me?
Yes, Ken.
Dave Julian, I'm a director of Mutual One. Good seeing you again.
I did. Yep.
And I wanted to thank you, first of all, for being here tonight. More importantly, for defending all of us and protecting our rights for the 5-year battle that you had. I've got a brief statement. A brief statement and a hitchhike on some of the things that were said here. Mutual One adopted policy 7025, stating that we will abide by and be governed by all of the laws pertaining to an HOA or a CID, specifically Davis Stirling. As you know, there's a lot of controversy in Leisure World. Some other mutuals are possibly in the process of adopting it. Currently, as of tonight, 4 mutuals have signed on with the attorney that has a new law firm that was in opposition in the amicus brief. My question is this. For Mutual One to clarify this legally, and any other mutuals that would want to join in, would you be willing to represent us? You have the experience.
That's an issue.
You know the battleground.
That's an issue that we would probably best discuss in a smaller setting.
Can we do that?
We can discuss that in a smaller setting.
Very good. Good seeing you again.
Good seeing you. Thank you.
Yes, sir. I have 2 real quick questions. Early in your comments... All right, okay. Early in your comments about the governance bucket, as you called it, you mentioned that there were, although the emphasis was on transparency, that there were a few things that could be discussed behind closed doors. Can you describe what, maybe 1 or 2, or the idea of what the kinds of things that would be? And my second question is this. In the flyer that I received, it says that this presentation is regarding our rights, protections, and the value of our homes. Could you speak to the third one there, with how this affects and what would go on with, what concerns do we have with this with regard to the value of our homes?
Okay, taking the first question first, which is what things can be discussed behind closed doors. It's really a very short list, and one example would be certain types of personnel issues, and that would be typical of most businesses. You'd want that sort of thing discussed behind closed doors. On the other hand, the Davis-Stirling Act makes it very clear that a lot of personnel information is discoverable. It can be obtained under the Act, but that would be one example. As far as the value is concerned, I believe that, and by the way, this may be neither here nor there, but I'll mention it anyway. In addition to doing a lot of pro bono work where I've represented the rights of homeowners against boards of directors or against communities where the rights of the Davis-Stirling Act have been violated, I was also, I'm not currently, but for 16 years, I was on the board of directors of my own homeowners association. So I really have seen it from both sides. So for those of you who are on boards of directors, I know what a thankless job it is. Probably very few people ever say thank you to you. But you're not entitled to a thank you for everything. And that's one thing that I learned as well. As much as you want to get appreciated for the good things, you do. None of us are perfect. And so based on my experience, both in my law practice and in living in a CID and so forth, I think that being in a common interest development that's subject to the Davis-Stirling Act is something that does have a positive effect on property values, and real estate people could debate how significant that is. One variable that needs to be identified in connection with that answer is that it's not just the fact that your community is under the Davis-Stirling Act that would possibly increase the value. Another relevant factor is how functional your community is, whether it's subject to the Davis-Stirling Act or not. And if you have a community that's regarded as dysfunctional in the marketplace because there's a lot of disputes going on and so forth, that would be a drag on values, whether it's under the Davis-Stirling Act or not. But generally speaking, if the procedures of the Davis-Stirling Act are followed, if there's a civil community, such as I believe you have for the most part here, I think being part of that statute and acknowledging to purchasers coming in, new people coming in, that you are subject to the Davis-Stirling Act is a selling point, because people know they have the certainty, they have those three bundles of rights when they walk in the door. They know that they don't have to worry about, well, gee, what is this year's board may be great, but what's next year's board going to be like? The Davis-Stirling Act removes that uncertainty, so people, when they're buying in, don't have that on their minds, because they know exactly what they're buying in that regard.
Yes, years ago I worked in a law office, and I remember a wonderful Latin term. It was nunc pro tunc, where you went back and corrected a wrong that was that happened, or something that was omitted from a pleading. Would that be something that we could possibly think of? Because they did have a long, prolonged litigation before, and at that time there was no definition as to whether the rest of us were included. So, but could we go back and have that corrected by the same court?
As far as the mutuals, you mean?
Yes, as far as all the mutuals, the rest of it.
No. At this point,
That wouldn't apply.
No, at this point in time, the Golden Rain case is over, and if there was a new case that was filed that addressed the mutual, it would get assigned to some judge. It might be Judge Bauer, who decided the Golden Rain case. It might be another judge. But since there is a procedure for case assignment that is designed to ensure that related cases are assigned to the same judge, and if the mutual case was pending at the same time as the Golden Rain case, they would have been related and they would have been decided by the same judge. But since that case is over, any new case would just be randomly assigned to some judge, and it might not necessarily be the same one. As efficient as it might be to have the same judge handle it, it actually probably would be a new judge, a different judge.
Okay, thank you.
Hi, I'm Carl Borhaney. Thank you so much for coming. I'm in Mutual 5. Do you know about our recall election?
No, I don't.
We have a recall election on Friday to remove all of our directors and replace them with directors who will support the Davis-Stirling Act and also will not honor the new occupancy agreement that the directors adopted, in my opinion, illegally, because as a governing document it can only be adopted by a majority of the shareholders. And we actually had a majority of the shareholders present signed petitions at that meeting for them not to adopt it, and they did it anyway. My question is, I solicited documents from the Secretary of State and received back one dated in 2003 that our mutual had filed SICID under Davis-Stirling in 2003 and evidently have not filed since. Where does that leave us?
Well, the law does require all corporations to file statements with the Secretary of State on a periodic basis, and if those statements are not filed timely, the corporation can be subject to forfeiture, and that can be a bad thing. It also can be expensive to correct. It can be corrected, but it can be expensive to correct. But for example, it could jeopardize the validity of contracts that the mutual has entered into. It could create other problems. So it's very important for all corporations, including corporations that are subject to the Davis-Stirling Act, to make sure that they file their filings with the Secretary of State on time, that they file their tax returns on time, that they stay in the good graces of the Secretary of State, the Franchise Tax Board, and the federal government as well in terms of all the filings that are required. So it would be a problem that should definitely be corrected as soon as possible if required filings were not made.
Referring to the filing of the 2003 SICID under Davis-Stirling, the fact they stopped filing those evidently in 2003, how does that affect our Davis-Stirling standing?
Again, there's this substance over form rule that I would refer to again, and the fact that the Mutual at one time, even if it was in 2003, said that it was a CID would be a relevant fact. The fact that they, if there was a later date and time when they were saying they were not a CID, you'd have to evaluate the circumstances of that and to see whether that was motivated by an agenda and therefore was less credible than the evidence of what happened in 2003. So anyway, you'd have to look at the whole array of facts, and no single fact. The filing of a statement that is acknowledging CID status or the filing of a statement saying declaring non-CID status would be dispositive. You'd have to look at all of the facts and circumstances, and that's the way the issue would ultimately be determined, not on one single fact. So it wouldn't ride, the issue wouldn't ride on that alone, although it would be highly relevant.
I understand. Thank you. Just real quickly, the fact that our structure is what it is, we have units that are accessible to people individually and only, and also in common areas. Doesn't that make us a common interest development under Davis Stirling?
Again, broadly speaking, the purpose of the Davis Stirling is to provide protections for common interest developments, and common interest developments are typically structured as separate interests, such as the rights that people have in their co-ops or their condominium units, what have you, coupled with an interest in common area or in common easements. And yes, that is what you have in broad brush here. And again, this is exactly the issue that we addressed in the Golden Rain Foundation case. When you have separate interests coupled with a right in common facilities, common areas, common easements, and so forth, that is the foundation of what a CID is. So then you're just looking at the technicalities of it and getting into all the other evidence to see whether there's an argument that can go against that.
Much appreciated, Mr. Wright.
Thank you.
You did mention earlier, Steve, that there is certain times when they can go into executive session.
Yes.
And recently, the Golden Rain Foundation had a contract offer from T-Mobile. And I went to that meeting. It was a special meeting. They were going to talk about T-Mobile contract with Golden Rain. Then they said they're going into executive session for a third-party contract. Is that a third party? I thought there's two parties, Golden Rain and T-Mobile. Who would it possibly be the third party?
I think I would assume that they're just saying that it's a third party to the community. In other words, T-Mobile is outside the community. That may be what they meant by that. Particularly if a lawyer was saying it.
No, it was the administrator.
Okay, well, I'm not sure what they were saying, but it sounds like the contract only has two sides. It has
Right.
T-Mobile, and then it has the mutual or the Golden Rain Foundation, whatever the case may be. Maybe there are other parts of the contract. I don't know, but it would be surprising. So I'm not really sure what they would have been referring to there.
Okay, but it would have to be another person, another party of some sort, like another beneficiary or whatever you would term it.
Right, and the discussion of a contract like that, I personally think, regardless of the niceties of the Davis Stirling Act, is something that really, I think you would want. It's a major issue in the community. It's a major contract. A lot of money is at stake. It also has quality of life issues because of what it relates to.
Yes.
And so it seems as if, again, this is a matter of good form, setting aside legal niceties, that's something that would want to be talked about out in the sunshine.
Right, thank you.
Thank you for being here, sir. I'm just curious here. Why are some of the mutuals covered by the Davis Stirling and others are not? Should we all be protected in the same way? And how do we find out if we're protected or not? I think based on the mutual we're in.
Yeah, the answer to the first question is shouldn't they all be the same? The answer, I think, is yes, because they're all the stock co-op mutuals, as far as I'm aware, are structured exactly the same way. I mean, they all have common area. They all have they're all stock co-ops, and so yes, I don't know of any differences that would legally justify the treatment of Mutual 2 under Davis Stirling different from the treatment of Mutual 16. I would think they would, that they would either all be within the Davis-Stirling Act, or they would all not be within the Davis-Stirling Act. Again, Mutual 17 is something different. But the other mutuals, to me, the same analysis would apply to each and every one of them. It would be very strange to have different results for different mutuals.
So with respect to Mutual 2, why is it so different?
I don't think it is.
But they were talking about having to jump through a lot of hoops to see if they were covered, didn't they?
Yeah, and again, if the current board of directors of a mutual acknowledges that it's subject to the Davis-Stirling Act and is operating the mutual subject to the Davis-Stirling Act, then in a way you could say that right now there wouldn't be an issue in that mutual because the Davis-Stirling Act is being followed. The issue, the problem is that what happens when the next board comes in if there isn't a clear precedent that the mutual is subject to the Davis-Stirling Act. The next board could come in and say, well, we've changed our mind. We don't think we are subject to the Davis-Stirling Act. And you can get into this problem of inconsistency and uncertainty from year to year, board to board.
Thank you. That answered my question.
Okay. Thank you.
My question is, it's pretty obvious to most residents that we benefit by being under the Davis-Stirling Act, correct? And my question is, if down the road, by some circumstance, we are made not qualified to be under Davis-Stirling, what persons and entities benefit by that being so, and short-term and long-term? Who benefits from that?
Well, in a way, that's a matter of speculation, but I can give you some examples from other communities of why the property management and the boards of certain communities have found it to be, have wanted to fight over the issue. In some other large communities, the issue of redevelopment is a big topic. And so there are interests that would want to take common area and sell it, for example, or change it into something other than what it is now. And there can be big dollars associated with that.
Into whose pocket?
Well, that would go into that would benefit the parties who are receiving in essence, your land. So it would benefit those private companies, those developers, what have you. It really wouldn't benefit anyone in the community. How could it when you're selling your property and you're not going to get the money? The community will get the money, but it's unclear how it would be spent. So the benefit would lie outside of the community, not inside the community.
Well, I would think that in all these meetings, that point should be stressed. And, then I don't see why there's any argument. It's pretty obvious what's going on.
Yeah, and there are other communities, kind of like yours, actually in Orange County, that are going through exactly this, where they are being redeveloped, and it's causing a lot of heartache.
So they think we're stupid, and they could do this with we're going to go, yay, go ahead, do it. I just don't understand that way of thinking, but thank you so much.
Thank you.
While I've been standing here, some of my concerns, my question has been answered. I was going to ask you if, in your opinion, it was more beneficial for us to become a CID or a homeowners association other than a mutual stock corporation. What's your feeling on that?
The structure that you've got now of being a stock co-op has worked for what, 40 years? Yes, it's worked for a long time, and I would think that it would probably continue to work pretty well.
So then can our mutual stock corporations fall under Davis-Stirling?
Yes,
Yes.
absolutely.
Okay. All right. So we can leave it just as it is, and still be protected by Davis Stirling?
Yes, I'm glad somebody mentioned this point because I didn't have it in mind when I walked in today, but I remember there being some discussion back in the Golden Rain Foundation case about how the Davis, if Golden Rain Foundation was subject to the Davis Stirling Act, that the sky would fall and all sorts of changes to the community would be necessary. And that wasn't the case with respect to Golden Rain Foundation, and it's not the case with respect to the mutuals.
It seems to me obvious then that we all, as an entire community, not just on a mutual basis, I mean, how do we go about approaching our boards of directors other than we've got to go to the meetings and we've got to get them to agree to establish our mutuals, individual mutuals under Davis Stirling?
Right, right. And you need to elect people that have broad support in the community. And that's critical. You do have the control over the election process. And sometimes it's hard because not everybody knows all the candidates, and sometimes the incumbents just get voted in, as in public office, whether it's the city, state, or national level. It just happens. And sometimes that happens in homeowners associations as well. But if you have an informed electorate in the community and you're electing people to the boards who are like-minded, then the problem in a way will take care of itself.
Except for the fact that when that board is gone, like you said in the beginning, who knows what the next board is going to do.
Yeah, that's the concern. That would be a concern.
Yeah.
Absolutely.
Okay, thank you very much.
One thing that I didn't mention before, and before Ed asked his question, and it's very important, I've heard from time to time some assertion that, well, the rights of the Davis Stirling Act are duplicative of rights in the corporation law, and therefore, since you have the benefit of the rights that are extended by the corporation law, you don't need the Davis Stirling Act. And nothing could be further from the truth. The reason the Davis Stirling Act was enacted was because the general corporation law wasn't sufficient to deal with the special things that go on in a common interest development in a homeowners association. So most all of the things that I talked about in those 3 bundles are things that you get as a result of Davis Stirling and do not get, and certainly do not get to the same extent under either general corporation law or nonprofit corporation law. Yeah.
I'm asking a question on how you can enforce the Davis Stirling after going through court and having Golden Rain declared a common interest development under the Davis Stirling, and yet they are violating some of the policies of the Golden Rain, of the Davis Stirling. As an example, they do not just charge for the transfer fee. They have an initiation fee that they have added, and they continue to collect. I thought that under my understanding of the Davis Stirling that they could not do that. They say, well, if golf courses do it, why can't we?
Well, there is a final court order out there that says that Golden Rain Foundation is subject to Davis Stirling Act and must abide by the Davis Stirling Act, and if that judgment, that final judgment, is not being followed, then arguably Golden Rain Foundation is actually, and this is just a legal term, so don't take it the wrong way, but they're in contempt. They're in contempt of that order.
How can you enforce that?
Well, there are procedures for enforcing judgments under California law.
Should we do that?
That's something that we should discuss in a smaller setting. A mutual went into bankruptcy that, might be a vehicle for some third party to step in and perhaps change things here in a way that the individual homeowners wouldn't like too much.
Because we have 15 mutuals on this block, then if one, let's say through fraud, went bankrupt, then an outside interest could, in theory, come in.
Well, once something like that happens, there are all sorts of scenarios.
You need protection, that's what I'm asking.
Yes, you do need protection for that, and the protection for that is the Davis Stirling Act by having responsible boards, by having engaged members who attend meetings and stand up for what's right and so forth.
Okay, so we here at Leisure, we're relatively new here, but we're under the Davis-Stirling Act. That's correct?
There is this court order that was issued that became final in 2008 that says that Golden Rain Foundation is subject to the Davis-Stirling Act. That case didn't address or decide the status of the mutuals, so there's no court order out there that decides the issue one way or the other, as we were discussing. I think
Okay, so therefore it's not solidified for the mutuals at all.
well, yeah, it's not.
That's what we need to do.
Yes.
Because if we don't, then we're subject to the developers or anybody coming in. It's like a loophole. Would you say?
Yeah, if there's any significant group with power in the community that contends that the mutuals are not subject to Davis-Stirling Act, then that's an issue that puts the entire community at jeopardy, in my view. And so it would be important to have the issue resolved in some efficient way, and so you have a binding determination that would prevent a board in the future from changing the rules.
Okay, so one more question would be, as you mentioned to one of the persons that was up here, that if we got retired judges to come together and do something, what would be the most feasible, economical way that we as the mutuals here could do something like this to take care of the situation?
Yeah, again, reasonable minds can differ on that. My personal view on that is that it should be done by an actual sitting judge as opposed to a retired judge, even a panel of retired judges. And I think with the rights of appeal, so that either side could go up to the Court of Appeal. But what I would suggest as well would be that the litigation be managed in a very cooperative way, recognizing that although there may be two sides that differ, it is an issue that needs to be resolved for the community and therefore should be resolved cost effectively and efficiently. And I try to manage a lot of litigation in my regular private practice that way because my fee-paying clients are interested in that as well. And ultimately any fees that are incurred on both sides are going to be paid by each and every one of you, which you don't want to do. You would rather spend your money on something else than on me or on somebody else. It should be managed very efficiently to keep, you can't eliminate the cost, but you can keep them way, way down.
So that would mean speaking to you in a smaller room.
Yes, exactly.
Thank you.
Graham McAllister, Newton Ryan. I believe you have suggested that a Division I general law corporation, which issues stock to its shareholders, issuing stock to shareholders is a distinguishing characteristic of a Division I corporation, might become a Division II, a non-profit corporation, which does not issue stock. Did I misinterpret you, or is that what you said? There's some way that the stock company can become a non-profit corporation?
I believe the answer to that is yes, but let me tell you, qualify that by saying that I am not a corporate lawyer, and the answer to that question is best given by a corporate lawyer, and that's what I was saying in response to the question very early in the Q&A session here, that you need to go out to a corporate lawyer and get a bid for that work or be told that it can't be done. I think it can be done, and I'm pretty sure it can be done. The cost of the mechanism of doing it is something that I have a question about, but I don't even think it needs necessarily to be done because I think as is, all of the mutuals are subject to Davis-Stirling.
But you cannot become I don't understand how a Division II corporation could have stock. It issues stock and have shareholders. That's a basic question. I think you're saying that's a corporate attorney's.
Oh, well, the mutuals are stock cooperatives.
Right. Division I corporation.
They're structured as general corporations, general law corporations, functioning as stock cooperatives.
That's right.
That's the way they're set up right now. And so the question you're asking is, can a nonprofit corporation be a stock cooperative?
But no, issue stock to its shareholders.
Well, the stock that's issued is the certificate that establishes your right of occupancy in the unit.
Which also, this makes us a general law corporation, because we issue stock. A nonprofit corporation cannot issue stock.
Yeah, I'm not sure that they're inconsistent, but again, that's an issue for another day.
Good evening. Thank you for coming here. My name's David Noble. I'm a director of Mutual 5.
Hi, David.
I've been an attorney since, can you hear me okay?
I can.
I've been an attorney since '73. I have about 30 years of corporate law experience. And I read Davis Stirling. You have two forms of associations, a nonprofit Division II corporation or an unincorporated association.
Correct.
Neither one of which has stock. But you read down on item 4, and a stock cooperative is included as a CID. In your opinion, is there an inconsistency in the law?
No, I don't think so. I take the law as it's written, and you're to read the statute and harmonize all its provisions as best you can. And so, no, I don't think that there's inconsistency there.
I agree with you. And by the way, the purposes articles for the mutuals are all on a nonprofit basis, as long as the mortgage is guaranteed by the federal government. What got us into this trouble is after the mortgages were repaid about 3 years early, and then the federal controls were taken out, and I've done some investigation. It turns out no application has ever been made for the mutuals to operate on a not-for-profit or non-profit basis. And I checked with the IRS, and they say you don't have to. That's an issue between the shareholders and the management and the directors. In your opinion, should the mutuals, as well as the GRF, file a good faith application to be tax exempt, to be under Davis Stirling?
I think that all of the mutuals, as well as GRF's required to do this, but all of the mutuals should operate as if they were under the Davis Stirling Act and should do all the things that flow from that.
And that would mean that they would be non-profit, is that correct?
The Davis Stirling Act, again, we get to this substance versus form. The fact of the matter is that they are not labeled as nonprofit corporations now. They're labeled as general law corporations. So what's the legal significance of that? I don't think there is any legal significance to that, given the way the communities operate. I know that some people would disagree with that, and they would say that if it's not a non-profit corporation, that's the end of the discussion.
Well, I've represented regular general law corporations that operate on a non-profit basis. They call it not-for-profit to distinguish it, but they have to file a good faith application, and for some reason, that's never been done here, and that is the basis of the argument for the people around here who are saying that we're not under Davis Stirling, is because they're operating on a for-profit basis. In my opinion, what they're doing is illegal.
Well, I'm not going to disagree with you.
Stephen, I just want to thank you once again for coming tonight and tell you what a pleasure it is to be able to see you outside of the courtroom.
Likewise. Thanks, Dave.
Now, going back to a question earlier in the evening regarding the exceptions to the Open Meetings Act, my question has to do with two of them. One of them is employee matters. Another is litigation or pending litigation.
Correct.
Another is member discipline when the member requests it to be in closed session.
Right.
And I've forgotten the fourth one now. Yes, the contracts. Thank you. So my question has to do with something that really bothers me every time I read minutes from my mutual, they consistently claim that they're having discussion on litigation. They call it legal matters. Not litigation, they call it legal matters. And I'm going, that isn't what the law says. You can't, virtually anything could be a generic legal matter. That everything could be behind closed doors if that were the case. How do we get a mutual to stop using that incorrect terminology, and so that we know what's really going on, and to be sure that they're taking our business in open session?
Right. Well, that goes to the heart of the matter that we're talking about here, is establishing that they are subject to the Davis-Stirling Act and then enforcing that. So that's what we're talking about. Okay. I have time for, let's take the three questions here, and then I'm going to have to rush off to the plane that's waiting for me.
Okay, I want to thank you also for being here. My name is Connie Lee, and I'm a mutual rep. Okay. Does this make sense? Shouldn't we all, as residents, go to our mutual board of directors and insist that the mutual is governed under Davis-Stirling, and have it put in our bylaws? Doesn't that make sense? Or could we do that?
Yes, you can go to the meetings and demand that the board take action to affirm that as basically a resolution, and put it in the minutes and so forth, and that would be very helpful.
That seems simple.
Yeah. But the boards can say no, and then you've got the problem. They shouldn't say no, but they could say no.
Thank you, Mr. Rice, for everything that you've done here tonight. I'll get right to the point if I can here. Do we have the right, as shareholders, we're all shareholders, we all have one share, do we have the right, under the democratic structure of the Davis-Stirling Act, to have a referendum vote, yes or no, that's simple, over the old agreement? And who is our adversary? Who wrote this new agreement? I still, of all the people I've asked, I still have no clue who has this new agreement. Who brought this up? It's worked perfectly for 47 years on the old one. What's wrong with the old one?
Right, that's a good question.
And can we vote on it?
I can't answer the second question.
Get this over with.
Because I don't know who wrote it, but as far as the first question is concerned, if it is a governing document, then Davis-Stirling would get the right to vote on it. And I also know that a lot of homeowners associations, by the way, just as a matter of policy and to keep harmony in the community, put big decisions out for an advisory vote anyway. And again, that's part of a board of directors that cares about what the residents thinks and wants to make a decision that's reflective of community sentiment.
All right, in reflection to what you just said, can we have an individual mutual vote? Can Mr. Julian of Mutual One, who I'm in, set up a vote for Mutual One to vote yes or no, simply to cut right to the bone here? Can we have the new agreement or not? And what's the vote, yes or no?
Yes, that can be done on a mutual by mutual basis, because the agreement is between each mutual and the residents in that mutual, correct?
Well, hopefully it would catch on after the vote, they'd all do it.
Right.
Because they're all separate corporations, am I correct?
Thanks.
Good evening, Mr. Rice. It's a pleasure to meet you.
Nice to meet you.
I'm Kurt Bohaney, president of Mutual 14.
Hello.
Hello. I'd like to ask you, when your plane returns, if you might avail yourself to Mutual 14 directors for a meeting.
We should discuss that at a smaller setting.
Okay, I think we have at least 500 people in the audience. I know I came a little bit late, but just for my curiosity and yours and for the camera, as far as directors and oncoming directors, can I ask the audience a question? Who would not like to be under the Davis-Stirling Act? Please raise your hand for the camera. We have one. I guess that's it.
All right. That's a great way to end this meeting anyway, at least my part of it, by bringing it all back to you. Because this is all about you. So anyway, thank you very much for the opportunity to speak to you, and a good evening to all of you.